without giving our time in that, I won't say much more than other than to say a huge thank you to Jill Witkin for chairing this panel, and we're all very much looking forward to it. So again, thank you, Jill, and over to you.
Okay, thank you, Ben, and thank you to the chairs for asking, the co-chairs of the conference for asking me here. My work these days, as I work as a Crown attorney, Crown Counsel, and almost all of my work relates to sexual assault cases. So I'm actually delighted to not be on a panel that has to do with sexual assault. This is quite nice for me. So without further ado, there are three great presentations, ones that I find really fascinating, and we're going to go one by one. I'm going to start with Danardo Jones, who's an assistant professor and PhD candidate at the University of Windsor, Faculty of Law, former staff lawyer at Legal Aid Clinics, and former director of legal services at African Canadian Legal Clinic, and he's intervened in cases before the Supreme Court, and his academic interests include criminology, penology, and critical race theory. So he's going to talk about the recent case of Stairs from the Supreme Court, which, as you know, was it was a domestic abuse case with a 911 call to a dwelling, and the Supreme Court had to deal with the permissible scope of a search incident to arrest for safety purposes in a person's home. And they certainly, as you'll hear, took a public safety and risk-driven approach, partially modifying the common law test. And this wasn't a case about race, but Danardo looks at the unstated racial and intersectional implications of Stairs, and maybe the gap in the court's decision in Stairs, given their discussion of race implications and police powers in the case of R versus Lee. So without further ado, over to you, Danardo, and thank you.
Okay, thanks.
And we need this slide up.
Yeah, I don't see. Okay,
there we go.
All right. So good morning, everyone. And I should say I'm in awe of the speakers that have gone so far. The session before was extremely generative and provided me with much insights on the current constitutional landscape. So I hope that, my colleagues and I, that we provide you with the same experience. So I'm going to be talking about Stairs. There's much I should say to say about this case, but I've limited my remarks in the interest of time, obviously, to focus on some of the unstated intersectional impacts of the decision. But before I get into that, I'll briefly introduce you to the case, I guess its ratio and some of the salient facts. How do I move to the next? Just press this button here. Oh, there we go. All right, neat. Okay, so Stairs, the accused here, or the offender, was witnessed repeatedly striking a woman in a vehicle. The police were called and responded. They scanned outside the home and saw the suspect's car parked in the parking lot. They knocked the door loudly. No one answered. They entered the home fearing for the safety of the woman. A woman with fresh injuries came up the basement stairs, and Mr. Stairs ran past the bottom of the basement staircase and locked himself in a basement laundry room. He was arrested a short time later. The police visually scanned the living room area of the basement and saw in plain view a clear container and a plastic bag containing what was later discovered to be crystal methamphetamine. Stairs was charged with trafficking, assault, and breach of probation. He was convicted of all the charges at trial. ANCA upheld the conviction and he appealed to the SCC. So what's the framework that was set out in Stairs? And the framework that I'm going to suggest leaves, I think, some pretty important intersectional blind sides, or does not take into consideration some really important intersectional blind sides. So Moldaver and Justice Moldaver and Justice Jamal wrote for the majority. So the framework, as you can see here, really modifies the baseline common law search search power incident to lawful arrest. And as you can see here, the test is as follows. So the arrest has to be lawful. The search has to be incident to arrest. The search will be incident to arrest when the following considerations are met, where the area search is within the arrested person's physical control at the time of the arrest. The common law standard must be satisfied. But here's where I'd say the rubber really hits the pavement with this particular search power is if the area search is outside the arrested person's physical control at the time of the arrest, but the area is sufficiently proximate to the arrest, the police must have reason to suspect that the search will further the objective of police and public safety, including the safety of the accused. Where the area searched is outside the arrested person's physical control at the time of the arrest, but the area is sufficiently proximate to the arrest, the nature and the extent of the search must be tailored to the purpose of the search and the heightened privacy interests in the home. So all of this seems on the face of it quite unremarkable, right? We've seen situations before where the courts have placed what I would consider to be a constitutional rider on this more broad power to search incident to arrest. So we saw it in Saeed, we saw it in Farron. So we've seen this before. This situation asked the court to consider this power within the context of the home, where obviously the privacy interest is quite heightened. Now, Justice Moldaver placed these searches on a continuum, which the minority justices took exception to say, well, we can't really put this on a continuum to suggest that, let's say penal swabs are, more, egregious or invasive than, let's say, strip searches and so on, right? We really have to look at the impact that it has on individuals' bodily integrity, their autonomy, their dignity. So one of the things that Stairs tries to do, and we often see this in police powers cases, is try to balance or strike the appropriate balance between protecting the sanctity of constitutional rights. And in this case, we're talking about, privacy, the right to privacy within somebody's home, and promoting legitimate law enforcement objectives. Now, this case had nothing to do with race. And one may wonder, why am I even talking about race here? But here's the thing, whenever we are dealing with either the expansion of police powers, the reifying of police powers, race is always a salient issue. And it's just not one of these things that we can suggest that this particular power, it's going to be applied across the board and it's going to impact everyone. Well, that's just not the reality, unfortunately. We know that the criminal law seems to be skewed in terms of its punitiveness towards particular populations. So whenever we're dealing with increasing police powers or over-equipping the police with powers to somehow attenuate whatever risk they face in carrying out their duties, we have to think of these racial or intersectional implications. Now, what are some of the intersectional implications that are perhaps unstated in Stairs? Well, here we're talking about searching homes. You'll remember in 2019, the Supreme Court of Canada addressed the issue of timing of detention in Lee. Now, Lee was not a case that dealt with Section 8. Section 8 was abandoned at the SCC level. It was raised at the lower courts. And Justice Lars, in dissent in the court below, talked about the spatial implication of race-based policing. He said, listen, if this was an affluent neighborhood, and he used the language of with higher fences, the police wouldn't have felt as brazen to step over what they described as a 2-foot little fence. So we have to think of the spatialization of race. We have to think about what happens in terms of police and the way they conduct themselves in neighborhoods that they consider to be somewhat outside the fold of the constitutional right to privacy. We know that high-risk communities, for example, doesn't seem to perhaps attract that level of sanctity, the sanctity that we talk about going all the way back to Seaman's doctrine, this idea of the castle being inviolable and so on. The idea is that when we think of the castle, is the subsidized home downtown Toronto, is that a castle that is deserving of this particular type of protection? Under the stairs doctrine, what we see is that the court says, well, if the search of the accused is within sufficient proximity, or the area to be searched is within sufficient proximity of where the accused was arrested, well, it's fair game because we're worried about police and public safety. But if you think about a multi-generational home in a low-income neighborhood, that scan, that brief scan around, that's the entirety of the home. You're not just impacting the privacy of the accused, but you're impacting the privacy of auntie, you're impacting the privacy of the cousin, privacy of uncle, the privacy of grandma, and everybody. And then there's also offshoot investigations that may come along with this type of, if you want to call it, sufficient proximate search, child welfare, immigration, and so on. And we know this from the critical race feminist literature. This is one of the reasons why Black women, and we've seen this not only in the US context, but also here in Canada, why Black women are perhaps reticent when it comes to calling police when we're dealing with issues of gendered violence. So this intersectional dimension is completely missing from the court's decision. It's important for us to bring that back on the table because it brings back, I think, into the doctrine, lived realities. We can't pretend as if race and its intersecting realities are somewhat outside of these particular formulations of legal principles. This paper is my attempt of trying to bring that back in the same way that the court in Lee brought in those realities. And I'm surprised that only a few years later, the same court seems to be engaged in this kind of retrenchment, where somehow social context is no longer perhaps important, or it doesn't have a seat at the table anymore. And it is my hope that, engaging in this particular discussion is that we will perhaps, have Lee live up to its potential. Because really that's what it did. It, in a paper I wrote after Lee came out, it said Lee did what I thought was lifting an embargo on race-based charter litigation. And then what we see in Stairs is, as I said, we're going back to this perhaps elision of race and its intersectional kind of realities. When we go back to this idea of neutral legal principles that just apply across the board, right? So I'll leave you with this. Think about, for example, where I currently live, let's say it's 2,700 square feet. Under the stairs power, I'm fine. My illegal activities could be going on upstairs in the East Wing. But where I grew up, that under this particular doctrine, my mom would get caught in this sweep, in this visual sweep, because it's somehow, protecting police safety or public safety. My grandma would have gotten caught in this sweep. My uncle would have gotten caught in this sweep because all of us lived in this house. And that's the reality. I've been lucky that education has provided me with the opportunity to be able to embrace the Siemens principle, this idea of I now have a castle. That's not the reality for a lot of my family members and a lot of folks in my community. And I worry that if we pretend that somehow everyone has this access or the ability to claim this principle that is as old as time, this notion of, you know, the castle and the inviolability of the castle, we seem to be perhaps either naive or just cruel if we don't take this reality into consideration. And I was looking at some statistics, and I'll leave you with this stats. StatsCan in 2016 said 21% of the Black population age 25 to 59 lived in what they termed as low-income situation, compared with 12% of their counterparts in the rest of the population. It's this reality that is completely missing from STAIRS. And if we pretend that somehow this reality is not important, then, as I said, the potential of Lee will be completely walked back to the point of obsolescence. And we ought to really try our best to ward against that. You know, Lee, as I said, opened up the new vista for fair decision-making. And we ought to really allow that decision to flourish and not walk it back. Thank you.
Thank you so much, Danardo. That was very enlightening. It shows us how context is so important in all these cases. We're going to move on now to the right to counsel interrogation stage with Amar Khoday, who's an associate professor at the University of Manitoba, Faculty of Law, and his academic interests include the legal norms governing the admission of incriminating statements elicited in interrogations. So he's going to talk to us about that lifeline of right to counsel. The single most important principle in criminal law, is the Supreme Court just enunciated in Lafrance, and maybe take us back to Sinclair and the Supreme Court's statement that the right to counsel does not include counsel being present at interrogations, but sometimes in certain circumstances, it can include reconsultation. And that's what Lafrance and Dussault left us with. And Amar is going to consider whether reconsultation is sufficient, whether the police are equipped to make that decision, and whether there should be something more robust. So take it away.
Thank you so much, Jill. So in approaching this talk, I decided not to just do one case. I decided, well, there's, as Jamie pointed out earlier, there were so many criminal law cases, and every time they came up with something, I was like, oh, Ben, I want to write about this. And then that was Dussault, and then months passed, and I'm like, oh, now there's Lafrance. What do I do now? So what I'm going to try to do is I'm going to try something ambitious, though possibly foolish, is to try to take these two cases, but there's something in common to them both, as Jill indicated. Both of them invoke the issue of the right to counsel, okay? And specifically in instances where, so both accused in these cases were arrested for murder, okay? They both were provided the opportunity to consult a lawyer at the first instance by phone. Subsequent to that, they both were interrogated. It was during this interrogation where it seemed to give rise to some issue about whether or not, well, they actually, it seemed, wanted to talk to a lawyer again. And of course, the police officers in those cases kind of invoked Sinclair to say, no, you don't get it. You already got your chance to talk to a lawyer, and we're not going to give it to you. So this goes to the Supreme Court of Canada. Supreme Court of Canada says, nope, you were entitled to this right to reconsult counsel. So while I in general agree with the outcome, and I like what they did with the decision, or at least on the outcome, I want to think about the ways in which, not to be overly happy with the decision, but to think about, reflect broadly on, well, does this give us an opportunity to think about, well, even though they talk about the idea of what circumstances may give rise to the ability to reconsult counsel, is that enough? Do we need to rethink this idea of Sinclair? So just to put ourselves on the same page, 2010 in Sinclair and a companion case, McCrimmon, the court held that an accused doesn't have the right to have the presence of a lawyer during an interrogation. Okay, that's the bottom line there. But they provided three circumstances, three non-exhaustive circumstances in which individuals could reconsult counsel if that happened. So going to, so as we revisit or I think about Sinclair, there's a few thoughts that go into this. So one is the idea of, if we look at section 10 again, well, we kind of have to go to the text of the Constitution in part just to see what does it say? Does it afford the possibility to have the presence of a lawyer while you're being interrogated? So I'm going to move to the next slide. So the text of section B, the English text, says everyone has the right on arrest or detention to retain and instruct counsel without delay and to be informed of that right. And I should mention, of course, my vision or my idea about why a person should have the right to have a counsel present during an interrogation strongly relies on the dissenting, co-authored dissenting opinion of Justice LaBelle and Fish in both McCrimmon and Sinclair. So in that decision, they both talked about the idea that the notion of retaining and instructing counsel suggests a broader relationship, not just simply one where you get information before your interrogation and then you move right along. But in addition to the English text, they also drew on the French text, which I think actually supports it even more. So, chacun a le droit, so everyone has the right en cas d'arrestation ou de détention. So, in cases of or in the event of arrest or detention, so d'avoir recours sans délai à l'assistance d'un avocat. So to have recourse without delay to the assistance of a lawyer or counsel, and to be informed of that right. So that language of the assistance of a lawyer suggests a broader duty, responsibility, or a power that lawyers are given. Now, neither the French nor English text limit in any way the idea or is expansively written so that it says you're allowed to have it during interrogation, nor does it limit it simply to a pre-interrogation consultation. It's the court that has decided to limit it or in these ways. So I want to suggest that given this language, there is room for the Supreme Court at some point to maybe revisit this idea that it has a more expansive role. And I want to touch upon two quotes that the courts in in one case in Dussault and the other in Lafrance, where they drew on two quotes, one from the Ontario Court of Appeal, the other from the Alberta Court of Appeal, which I think is actually striking and maybe supportive in some ways of this expansive idea. So the first comes from a case from the Ontario Court of Appeal. This was a quote from Justice Doherty from R.V. Rover, and they cited this in Dussault. So the right to counsel is a lifeline for detained persons. Through that lifeline, detained persons obtain not only legal advice and guidance about the procedures to which they will be subjected, but they will also the sense that they are not entirely in the mercy of the police while detained. The psychological value of access to counsel without delay should not be undermined. Now, I just want to stress here, of course, Justice Doherty wasn't making a pitch here for having the presence of counsel in the interrogation room. I just want to be that clear. I don't think he was intending to say that, but I think that metaphor, the simile as a lifeline is actually striking, because I think it's to be a lifeline is more than just simply being on Who Wants to Be a Millionaire and you're phoning a friend. I think it actually stands for something broader than that. A lifeline, given what that means, suggests at the very least maybe having that, if a lawyer is available and you seek to have that person in the room with you to help you, give you advice, i.e. to remind you to shut up. And that you have the right to silence, so you don't have to speak, okay? The other quote, and this comes from Lafrance, is, and this, Justice Brown cited this a couple of times in his decision, so it's from the Alberta Court of Appeal decision in Lafrance. The consultation with counsel provides an opportunity for a lawyer to inform the detainee of their rights, but also to discuss the benefits and drawbacks of cooperating with the police investigation, as well as strategies to resist cooperation, should that be the detainee's choice. So it's that language of providing you with strategies to resist cooperation. Now, just at a practical level, just think about, you talk to a lawyer before interrogation, they're giving you all this information. That in consultation can last anywhere from a few minutes up to 15 in the case of Lafrance. Now, how much time, how much do you think a person that circumstance is going to remember all of that, especially when the interrogation lasts several hours? And in fact, Justice Fish and LaBelle said, look, it's one thing to remember that advice 5 minutes after as the interrogation starts. It's a whole other story, hours into that interrogation. So, and maybe this is where the consultation part comes in, but I would argue this idea of the role that counsel provides to remind you of the strategies to resist, to have them right next to you, again, if available and they're sought. Okay, so with that in mind, and we know the reality is that's not the law. So let's turn to the actual law as it presently stands. So the court in Sinclair identified 3 non-exhaustive contexts in which a person may be able to reconsult counsel after they've gotten the initial one and after the interrogation has started. Just for the purpose of time, I'm going to hone in on number 3 because that's what the court was dealing with in Dussault and Lafrance. So where there is reason to question the detainee's understanding of their rights. Okay. So let's go talk about the cases now. So in Dussault, as I mentioned, he was arrested for murder as well as arson. In very quick succession after he's arrested, they take him to the police station. He indicates he wants to speak to a lawyer, picks a lawyer randomly out of the phone book that he's given. He picks an individual name, I think it was Jean-François Benoit. He talks to Mr. Benoit for about 9 minutes, and it becomes clear to Mr. Benoit, or he perceives that Mr. Dussault is not getting it, is not understanding the advice he's getting after those 9 minutes. So he says, listen, I could come down to the police station and give you an in-person consultation. Would you like this? Yes, I very much would. So he then says to Mr. Dussault, okay, can you please pass the phone to Sergeant Detective, I think it was Chicoin. And Sergeant Detective Chicoin says, no problem. We'll let you, we'll hold off and you can come in. So he passes the phone back to Mr. Dussault, and Mr. Dussault says, he tells Mr. Dussault, okay, you're going to be put back in the cell till I get there. Don't speak to anybody, blah, 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 blah. And that's what happens. What follows from that is Detective Chicoin talks to either his superiors, colleagues, and has decided, no, he's already consulted counsel. We're not going to allow him to have this in-person consultation. They tell Mr. Benoit, the lawyer, Mr. Benoit responds rather volubly. But at the end of the day, he comes to the station, is not allowed to see his client. They then interrogate, they let Mr. Dussault sit in the cell for some hours, finally bring him in, and they start to interrogate him. In the context of that, Mr. Dussault's like, wait a minute, I don't get it. My lawyer told me that he was going to come to talk to me first before this is happening. I don't get it. Why would he say that and not follow through? And I think it was at this point, Sergeant Detective Simon says, well, I can't get into your conversations with your lawyer. And then at some point, Dussault also again repeats, well, I don't get why you would say that. I'm feeling alone now and like isolated. And said, well, the important things you got to talk to your lawyer. That's now that we've settled that, I'm going to put that aside. And then they go on interrogating him. And of course, he incriminates himself. That's the facts and the police actions giving rise to the Section 10 breach in Dussault. Then moving to Lafrance very briefly, there's 2 interactions Mr. Lafrance has with the police, one in late March of the year, that particular year, and one in April. I'll just sum it very quickly. In the April instance, there was a search warrant. He's told to leave the apartment so they can execute it. They also say, please and thank you, can you come to the police station, have a conversation with us? He does so. He rides in a police car. They don't advise him, as I recall, they don't advise him of his right to counsel because, hey, he's voluntarily going there. And in that context, they ask him all sorts of questions. He seems to volunteer a bunch of the answers. They start feeding this to the officers on site who are performing the search. All said and done, the Supreme Court holds that that interaction violated his Section 10B rights because it really was a psychological detention, and they didn't even caution him. Okay, 3 weeks later, they go and arrest him, and they probably give him a proper caution. He's informed of his right to counsel. He exercises it. He speaks to a legal aid lawyer, talks for about 15 minutes, I think it was. And somewhere in there, apparently the legal aid lawyer says, yeah, before the interrogation, you might want to actually talk to someone again, meaning before the interrogation starts in person, because I'm presuming from that, similar to Dussault, he might not be getting it. Remember, Mr. Lafrance is 19 years old. as the court describes it, he's not particularly sophisticated, at least not in terms of, experiences with the police. He has no priors. So that's his experience going into this. So the police interrogate him for several hours. At some point, it starts to turn more adversarial, to the point where Mr. Lafrance is now saying, I think I'd like to talk to my dad now. And then the police officer's like, okay, I don't understand. Why are you saying that? And Mr. Lafrance says, well, it's just that I think it's my only chance to speak to a lawyer. And Sergeant Eros, who was the interrogator, says, well, just so you know, you might have been being given bad advice, or maybe there's a misinterpretation here, but you're not allowed to talk to another lawyer. You've already gotten that. And then I think Mr. Lafrance pipes in and says, oh, well, no, I mean simply that just to speak to me in person before we keep talking. In any event, Sergeant Eros continues his interrogation, and Mr. Lafrance incriminates himself. So the court holds that by not allowing Mr. Dussault, as well as Mr. Lafrance, to reconsult counsel, they undermined, one, in Dussault, the advice of counsel. And here it wasn't as if Mr. Benoit gave Mr. Dussault a whole lot of advice. It was clear that there wasn't a whole lot of understanding happening, but just the idea that he said, I'm going to go attend at the police station, and didn't show up. And the court emphasized this idea that, well, why would he tell me he's coming? And now I'm feeling isolated. The court actually honed in on that, which I think is an interesting decision in comparison to a lot of earlier decisions dealing with the undermining of counsel, where in actually earlier cases, police actually did say statements that undermined counsel in some way, whether it was disparaging them or whatever. In this case, there was nothing similar to that. In Lafrance, it was also one of the things that the court highlighted was this idea that it was clear that he wasn't clearly understanding the advice that he was given by his legal aid lawyer, but also the court picked up on the fact, again, that this was an individual who was, again, 19 years old, and wasn't necessarily sophisticated in this kind of context. And it was clear that he needed a reconsultation. They also picked up, and this, I was just thinking about what Danardo was mentioning about how, well, we have Lee, and then have they sort of abandoned this? And interesting, in these kinds of section, like 10 or 9 or 10 cases dealing with detention, the court did talk about the idea of Mr. Lafrance's indigeneity in this case. That being said, the court was also unclear about how they should deal with it in this case. It's just like, we're not sure how it really plays, but hey, we've made a thing about it in the past, so let's just throw this in the hopper. But they didn't really concretize it. It really went to the age and sophistication point. So all this to say, I think that the decisions, I like the outcomes of this, but I think when we think, that's my own timer to tell me to shut up. So I'll just sum up and just say, I think that while it's good that individuals are able to reconsult counsel, I think these cases also highlight the idea, well, maybe certain people need to have their lawyer present during these moments, whether you're racialized or not. And certainly in cases like this, where you might not be sufficiently sophisticated to deal with this in that way. I have a few other thoughts, but I'm going to save it for the Q&A perhaps, and I'll bring that up later. So thank you.
Thank you so much, Amar. Lots to think about there. And I have a question if we get time. All right, we're going to move now on to remedy, and Chris Rudnicki is here. Chris is the well, he is an academic, but he's also a practitioner. He's a defense counsel, and he appears at every level of court, mostly doing criminal appeals. He also holds an LLM from Osgoode, and he lectures, publishes, and mentors. So Chris is going to talk about the Beaver case, which, talked about the fresh start doctrine, and that if there's a charter breach, the police can sort of rectify that with fresh start, so that the evidence will not have been obtained in a manner that infringed the charter. But Chris is going to talk about remedy, and if 24-2 doesn't cut it, like it didn't in the case of either Beaver or Lambert, is there maybe another route that courts and counsel should be thinking about, for example, 24-1. So over to you, Chris.
Thank you very much, Jill, and thank you all for coming today. It's a pleasure to be here and a pleasure to get to participate in such a wonderful sharing of ideas. So as Jill mentioned, my paper is about the Supreme Court's decision in Beaver from 2022, and really, taking that very narrow litigator's perspective, I try and say, so if Beaver narrows our access to exclusionary remedies under 24.2, is there another way we can get at that same problem? So my paper moves in three parts outlined here as well as presentation. First, I say that Beaver restricts access to 24.2. Second, I say that this is a problem because it's going to leave some gap cases where you have worthy claimants who are deprived of a remedy. And third, I take a look at the development of section 24.1 exclusion and without changing anything in the law, say that that's available as a remedy where 24.2 wouldn't apply. So turning first to the Beaver decision, I'm going to walk you through the facts quickly and talk about how the court came to apply the fresh start doctrine in order to deprive both, just Beaver access to 24.2. The facts are that Lambert and Beaver are roommates. They call police and say, we found our other roommate, Bowers, dead when we came home. The police are suspicious when they arrive on scene. The senior officer on scene, looking for a way to control these two gentlemen, but not exactly sure how to do it, orders them to be detained under the Medical Examiners Act. They are detained under that act and questioned for 2 hours. But the problem is that the Medical Examiners Act does not exist. So they're taken to the station, again, under the authority of the Medical Examiners Act. Homicide officers arrive on scene. Up to now, they've been dealt with by the sort of street team. Detective DiMarino is in Lambert's interview, and he pauses it because he learns, oh, they're roommates. That's helpful information. I'm going to go share it with the rest of the team. At that point, he learns that neither suspect had actually been placed under arrest. That's my rendering of what I imagine his reaction to have been. So they immediately formally arrest both suspects for murder. They are each given fresh rights to counsel. Lambert is told that they're going to start from the very beginning. Beaver is told that he's being read his rights to counsel because the homicide detective, quote, was a new person that he's going to be talking to. It's a bit less of a fresh start in that case. And then after 12 hours of further interrogation, they both confess. Lambert confesses first, and then Lambert's confession is shown to Beaver, which then prompts his confession. They don't confess to murder, but they do confess to having lied in the 911 call and that Bowers died in the fight, not they didn't just find him. And they're both charged with manslaughter and obstruction of justice. At the trial level, the trial judge finds this sort of cascading series of breaches. And in Lambert's case, there's actually 2 10B breaches because the officers, after saying, do you want a lawyer, and him saying yes, continue to elicit incriminating evidence from him. At the trial level and at the Alberta Court of Appeal, they both find, well, the arrest for murder cured the prior breaches. And so the confessions were not obtained in a manner that infringed the charter right, and 24.2 does not apply. Both men are found guilty. The issue at the Supreme Court, or at least the issue that I'm interested in, was can police make a fresh start by complying with their charter obligations and put subsequently obtained evidence beyond the scope of section 24.2? The answer from the majority is yes, per Justice Jamal writing. There's 2 steps, and this is not new law. There's 2 steps to a section 24.2 analysis. There is first a threshold requirement, which requires the applicant to establish that the evidence was obtained in a manner. And only after you make that first requirement do you move to the evaluative requirement. We're all familiar with the Grant test, which asks whether or not the admission of evidence would bring the administration of justice into disrepute. And Justice Jamal holds, paragraph 97, that evidence will not be obtained in a manner that breaches the charter right when the police made a fresh start from an earlier charter breach by severing any temporal, contextual, or causal connection between the breach and the evidence obtained, or by rendering any such connection remote or tenuous. And that's about it. He provides as well a number of sort of tips for how to apply this, but that's really the test right there in paragraph 97. So in the result, they dismiss the appeals, although they do hold that the lower courts erred by saying that the breaches were cured. The breaches were not cured, but the connection, at least for Lambert, was severed because of we're going to start from the very beginning language. Beaver's confession was obtained in a manner because homicide detectives referred to their earlier improper, unlawful caution, but they still didn't exclude his statement. They admitted it. under the evaluative requirement. And so their manslaughter convictions were affirmed. The dissent in pretty strong language said, no, this is not a thing. This does not exist in our law, but they did not carry the day. So that's the decision and that's the holding. And now I want to talk about why, it probably is already obvious, but I want to talk about why I find that's problematic. First, on a practical level, it's going to make it harder to succeed on 24-2 applications. It's just going to make it more work for the defense. There's a double burden because the burden doesn't ever shift to the Crown under the threshold requirement to show that there's this fresh start. The burden is still with the defense. So the defense has to both prove first the connection and then prove that there's no fresh start. So that's going to make it harder for the defense. There's also a double benefit to the Crown, which is that, of course, during the threshold requirement, they could rely on the fresh start doctrine to deny access to 24-2, but also under the evaluative requirement, the grant test, they can make the case that the lack of a causal connection between the breach and the obtaining of the evidence diminishes its impact on the applicant's charter protected interests and therefore pulls less strongly in favor of exclusion. That's just the practical problem, although maybe that's not such a big deal. The more fundamental issue for me is that the fresh start doctrine is inconsistent with the fundamental principles that animate section 24-2, which are dissociation, vindication, and proportionality. Dissociation justifies exclusion because the courts need to distance themselves from other state actors and affirm their role as the guardians of our constitutional order. Vindication justifies exclusion where the courts are signaling that the charter is not dead letter, that your rights have meaning, and so therefore you're going to receive a remedy when they're breached, or at least when they're seriously breached. And proportionality, which is the limiting factor, which justifies exclusion only where it's proportionate to the need either to dissociate the courts from the breach or to vindicate the charter right. And you'll notice that those three values track the test in grant: the seriousness of the breach, the significance of its impact, and society's interest in adjudication on the merits. So the fact that, and again, the way in which the fresh start doctrine is problematic for achieving those purposes is that it doesn't even let you get to the evaluative requirement. It denies access completely to 24-2. Doesn't matter how serious the breach is, doesn't matter how significant its impact, you can't exclude. And so that's why I say it's inconsistent with those three values. I've thought up some gap cases just to sort of illustrate the problem. These are all cases that I have seen in my practice and that sort of came to mind when thinking about Beaver. The first is where you can imagine an arrest that's conducted with grounds to believe an offense has been committed, but that's conducted with excessive force. And so you can imagine someone getting arrested and then getting punched or beat up or something like that. And then after that breach occurs, rights are given to the detainee, maybe an apology is given or something like that. You can sort of, really like manipulate the facts however you want. And then there's a statement that's taken where incriminating evidence is given. I think the fresh start doctrine would cut off access to 24-2 there. Another example is a strip search case. This happens actually a lot in impaired driving investigations, where someone's arrested for over 80, they're taken to the station, and then a strip search is conducted, not because of their specific risk factors, but just as routine policy, which was rendered unequivocally illegal more than 20 years ago in Golden, but still definitely happens. And rights are then given after the strip search, and then breath samples are taken. That arguably there's a fresh start there. And then racial profiling. Racial profiling occurs not just when someone is arrested because of racial stereotypes, but when their treatment is affected by racial stereotypes. And you can imagine, and in fact, I've encountered cases where the accused is arrested, their treatment is impacted, is racialized, and then evidence is subsequently collected after rights being given and so on. There's a specific scenario that I provide in the paper that is influenced by a real life experience. So that's the problem of Beaver and of its restricting access to 24-2. So then the final move in the paper is to ask the question of whether or not we can fill the gap with 24-1. And there's a really cool story here, which is that in the trial level decision in the famous case of Therens, which was rendered 3 months after the charter came into force, Justice Muir, sitting in the Saskatchewan Provincial Court, sort of reads the text of the charter and invents his own Section 24 test because one didn't exist yet. The breach there was lack of access to right to counsel. Mr. Therens was arrested actually a week after the charter came into force. He drove his car into a tree in Moose Jaw, Saskatchewan, and he's not given his rights to counsel. And this is Justice Muir's test. So there's the first question, which is the evidence obtained in a manner that infringes the charter? If yes, the trial judge has a duty to exclude it, where its admission would bring the administration of justice into disrepute under 24.2. And if no, the trial judge has a discretion to exclude it, where they consider it appropriate and just in the circumstances. He gets slapped down in the Supreme Court, but I'm going to review 3 cases with you right now that show that we have arrived now back where Justice Muir started. He got it right in that exclusion is an available remedy under section 24.1, and he got it right in that trial judges have the discretion to exclude under this provision. Those 3 cases are White, Bjelland, and Babos that I'm going to review with you now. How am I doing on time? We're doing okay?
A few more minutes, yeah.
Okay. So White's a case from 1999. Again, in Theron's, the Supreme Court says exclusion is not available under 24.1, and they're pretty unequivocal about it. But the court revisits that ruling in 1999 in White, which is the case about whether or not statements that are compelled by statutory legislation can be admitted in a criminal trial. The answer is no, because it would be contrary to the right against self-incrimination, and exclusion is justified under section 24.1 because it's necessary to preserve trial fairness. And they actually specifically revisit, in this case, they revisit their ends. They say that, that's not what the court meant, even though it's clearly what they meant. And 24.1 is an available mechanism for excluding evidence in this narrow kind of circumstance. Then in 2009, you have the introduction of an additional category called the residual category, where it's not just about protecting trial fairness. In other words, you can't only exclude when it's necessary in order to make sure the trial itself is fair. It's also available where exclusion is necessary to sort of protect general fairness concerns, to preserve the integrity of the justice system. That's the residual category. And the residual category, I say, is an available remedy where it's necessary to dissociate from state misconduct and to vindicate the charter right. Then you have Babos in 2014. In Bjelland, it was about trial fairness. So Bjelland did not actually end up doing much with the residual category. But then in Babos, you have the court really filling that in. And Babos is a case about stays of proceedings for abuses of process. And it sort of marries up the abuse of process doctrine with section 24.1. The remedy is justified under section 24.1 of the charter. And crucially, for my purposes, Babos affirms exclusion of evidence as a proportionate remedy, lesser to a stay of proceedings, that is capable of vindicating and dissociating in some cases. And in fact, in Babos itself, that's what happened. In Babos, the trial judge stayed the proceedings in part because police had colluded in their evidence about what happened with the search of the vehicle. So the trial judge stays, the Court of Appeal upholds the stay, and Justice Moldaver overturns the decision, finds that it shouldn't have been stayed. But in so doing says the trial judge's error was that he could have just excluded the gun. And the gun could not have been excluded under 24.2 because it was seized from the one accused and then admitted as against the second accused. So a long way of saying Babos, in my view, affirms that residual category exclusion is available as a section 24.1 remedy where necessary to preserve the integrity of the justice system. Here's the test, and I think this test could probably be changed. It seems a little unclear to me, but the test is first that you ask whether or not the prejudice to the accused right will be manifested, perpetuated, or aggravated through the conduct of the trial or its outcome. The second is where there's no alternative remedy capable of addressing the prejudice. So it's a bit, 24.1 exclusion is different than 24.2 exclusion in the sense that in 24.2, you don't ask about lesser remedies. You only look at exclusion. Under 24.1, you have to look at lesser remedies first. And then in cases where there's uncertainty between 1 and 2, then you bring in society's interest in denouncing the misconduct and preserving the integrity of the justice system must be balanced against its interest in a final decision on the merits. And again, crucially, it's a discretionary remedy. So again, for me as a litigator, I'm not asking necessarily what's the Supreme Court going to do with this. I'm asking, is there a basis for me to ask a trial judge to give me a particular remedy? And so I say yes, the answer is yes. The appellate case law makes it very clear that 24.1 remedies have very wide discretion. and that on appeal, it translates into a highly deferential standard of review. So as long as the trial judge hasn't made an error of law, hasn't made a palpable and overriding error of fact, or rendered a manifestly unjust result, that finding is owed deference on appeal, which trial judges like to hear. And it is for so it's for them to say when a section 24(1) remedy is appropriate. So that's why I come back to Justice Muir's test and I say that this is still the law, or I should say it is now the law. It wasn't when Theron was decided in 1985, but it now definitely is after White, Bjelland, and Babos. You first ask, was the evidence obtained in a manner that infringed the charter? If yes, you go into 24(2) and you apply the Grant test. And if no, then the trial judge has a discretion to exclude it where it's necessary to preserve the integrity of the justice system, and that's their call to make. My final thoughts, it seems clear to me that 24(2) has to be a tougher test than 24(1). It has to be a pretty serious breach. It has to have a pretty serious impact on the accused's charter protected interests in order to justify exclusion. I would have thought, given the factual matrix in Beaver, I would have thought that's an obvious case for exclusion, but obviously the Supreme Court doesn't agree with me. But again, it's the trial judge's call to make. Also, the trial judge is obliged to consider lesser remedies. Now, what might those lesser remedies be? The one that always comes up is sentence reductions. And I want to sound 2 notes of caution on that. First comes from Kent Roach, and it's that it kind of infringes the presumption of innocence when you're in the pretrial phase, as you most often are. And the second is from our friend Ben, which is that you're already entitled to a sentence reduction for charter breaches. According to the Supreme Court in Nassau-Gallowak, if there's a charter breach, it's one of the factors that ought to be considered in deciding whether or not a particular sanction is fit and proportionate. You don't need to bring a charter application first before you're entitled to that remedy, if you want to call it a remedy. So those are my final thoughts. I hope that was all helpful.
Well, I don't want to be against Chris in the Court of Appeal on this issue because, he makes some good points. All right. Do we have any questions from the floor? Yes, Dan.
Quick question, Chris.
Oh, the mic is coming over.
Could the Beaver case be limited to fresh starts in the 10B context? So as I understand it, the infringement in Beaver was a 10B. The initial infringement was a 10B. The 3 examples you gave were not initial 10B infringements. So I'm just wondering about that.
Yeah, well, so there was also Section 9 and 10A in Beaver, and it was it certainly wasn't just 10B. I think there's a recent case from Justice Pachaco at the Court of Appeal that first says that Beaver doesn't do anything new, and second, I think can be read in that way as restricting Beaver to 10B. I think I need to give it more thought. Certainly, Beaver doesn't say this is restricted to 10B. Beaver simply says the Fresh Start doctrine, wherever there's been a severing event, denies you access. The claim fails at that first evaluative requirement, and you don't get to the first threshold requirement. You don't get to the evaluative requirement. So I would certainly argue in a case where I was arguing, I would say Beaver is limited to 10B cases, but Beaver itself doesn't say that.
Are there, and I may have missed this in your presentation, are there still gaps if it is limited to the 10B?
I think so. I think that incriminating statements that even where there's a fresh start and someone makes a decision to speak with police after having been given rights to counsel, if there's a serious enough breach on the front end before that's done, in the case of Beaver is a great example. I think there should still be access at least to the question of whether or not the evidence should be excluded.
Question or comment for Professor Jones. I wonder if there's not a clearer hook for your argument in Stairs itself, right? So in the case of searches incident to arrest inside the home that are outside the physical control of the suspect, Justice Moldaver and Jamal say, well, the standard has to be reasonable suspicion that there's going to be a threat to safety. It's a reasonable suspicion is lower than credibly based probability, but it's also higher than the Castley kind of reasonable basis, which would allow for generalized sort of concerns, right? But then Justice Karakatsanis in the sense says, well, you say this, Moldaver and Jamal, But when you apply reasonable suspicion, what you're really doing here is you're not pointing to any specific objectively discernible facts. You're just saying, well, look, in a situation like this, right, it was fine to reasonably suspect that there would be weapons, etc. There's no facts that are pointed to. And so she says, you're saying that it's higher than, you know, generalized concern, but really that's what you're making reasonable suspicion to be. And that question of generalized concern or situation like this opens up a host of questions along the lines that you were discussing. So I'm just wondering whether that might not be an entry point.
Yes. So when we look at Justice Moldaver's police safety, public safety approach, and you know, we think about it within the context of this you know, threshold of you know, reasonable suspicion, I started to think about how we construct risk, and when, you know, when our police officers can be said to be objectively, okay, at risk, and their safety is at risk. And I start to think about this relationship between race, certain race-based narratives, and risk construction. It'd be really easy for police in this particular circumstances, given what Justice Moldaver talked about, this idea of this volatile nature and so on and so forth, for under the reasonable suspicion kind of doctrine or threshold to suggest that, well, given what we know, and here all of this is based on race-based knowledge, right? What we know about particular neighborhoods and what happened in these neighborhoods and so on, the police officers were reasonable in their suspicion that they were at risk, or at least someone was at risk. You know, someone in the public was at risk. So what it does is it really reinforces these race-based narratives, right? And I agree with the minority that indeed, we're talking about generalized suspicions here, right? This idea that the officer in his testimony said, well, I don't know, maybe there was a gun laying out on the table. It's like, where did that come from? Why did you suggest or even think that there was a gun laying out on the table? And for the majority to say, well, yeah, you know, in these situations, it's so volatile, you know, indeed, there could be a gun laid out on the table. It had me thinking about some of these pernicious and probably prevailing stereotypes, right, that exist in particular communities, in particular spaces, right, and how they go unquestioned, right? There's certain heuristics going on here where police officers, and what we saw in, you know, Justice Moldaver's decision, seem to be able to say, yes, in these situations, it's totally reasonable for me to think that there is a gun laid out on the table, or someone is hiding, again, to use the language in stairs, someone's laying behind the couch. This is what the police officer testified to at a trial level. There may be someone laying behind the couch. There may be a gun out on the table. Nothing in the factual matrix suggests that there was anybody else in the house other than the victim and Mr. Stairs, right? So I am concerned by that, but the question becomes, well, should we, you know, put in place this higher threshold of reasonable probable grounds in the way we did in the strip searching context, right? And the minority obviously said, no, reasonable suspicion is fine in this context, right? Because we don't want to hamstrung police officers in doing their jobs, right? But they would have adopted this imminent risk approach as opposed to the police safety approach. But then both approaches, we're talking about, you know, trying to, you know, figure out, you know, how risk should be not only constructed, but interpreted, and using the police officer's experience, you know, as the, you know, the way for us to understand, you know, understand when, you know, this risk or this safety issue exists. And I'm with you with, you know, the concerns around that. I'm not sure if we should leave it up to the police officer and their idea of what is risky, you know, in order to determine whether or not they had this reason to suspect.
That's why the court focuses on reasonable suspicion and objectively discernible facts. That's going to allow us to extradite someone from these kinds of gross generalization that might involve investigation. Right?
the majority cites J, but just doesn't apply.
Yeah.
Right? This is one of these classical moves where they say, here's the criteria, it's high, but really we're not applying it. And that's what's happening.
Yeah.
Okay, we have one final question because I think we're almost at the hour or are at the hour. One final question, yes?
Oh, yeah, just a question about Beaver. I had a lay friend point out to me. Rights don't actually exist, and they're just concepts that exist in our minds. They're not physical like the cup or the fork in front of me. So I guess the only real physical manifestation of a right is the remedy that we receive from the court. And if that's true, then shouldn't it be the case that whenever a right is breached, that there should always be an exclusion, regardless of whether or not it affects the administration of justice, simply because the existence of the remedy or the availability of the remedy is the recognition of the right?
The defense lawyer in me says, yeah, sure. But,
The crown in me says no.
But you can imagine, it's easy to imagine minor or technical breaches that shouldn't result in the exclusion of reliable evidence that's critical to the Crown's case. And also remember that a declaration is a remedy. Declaration that the rights have been infringed is the lowest remedy there is, but it's a remedy. And so I think that maybe in some cases, that's the question the court should ask itself is the lesser remedy of a declaration sufficient in these circumstances to vindicate the right and to dissociate ourselves from the police misconduct? Yeah, that's my thought.
And I'm just going to add one point, which I mentioned to Amar earlier about, his very robust idea of having looking at Sinclair again and having counsel maybe there at the interrogation. And I would just question whether, Chris, as a defense counsel, do you have the time to sit through an interrogation, which often are hours and hours and hours long, sometimes in the middle of the night? Who, is legal aid going to pay for that? Anyway, I just throw that out as the practitioner in me. I throw that out.
I focus on appeals.
Yeah. Good answer.
Sue's answer would be yes, they should.
Yeah. Anyway, thank you. I want to really thank the panelists. This was a fascinating discussion and really lots to think about and excellent presentations. And I encourage you all to read the papers when they're finally published. Thank you.